Okay, well, let's go ahead and get started. So for those of you online, sorry about the delay, just some slight technical difficulties with the camera, but we're good to go now. So it is my pleasure to introduce Sarah Hansen and Christie McLeod from Miller Thomson. So in the interest of time, I'll just give some very brief introductions, and then they can start their presentation. So Sarah Hansen is the leader of Miller Thomson's litigation practice group in Vancouver. Her legal expertise is in general commercial litigation. With over 24 years of practice, she has specialized in the areas of environmental and Indigenous law. She represents or has represented clients in complex commercial litigation matters in relation to various energy projects, focusing on regulatory and administrative law, environmental assessments of major projects, extra-provincial regulatory regimes, industry standards, sustainable energy practices, climate change, and environmental compliance issues. Christie McLeod is a member of Miller Thomson's advocacy group, where she regularly advises Indigenous communities and companies on environmental, Indigenous, administrative, and regulatory law matters, as well as ESG issues. She has appeared before the BC Court of Appeal, the BC Supreme Court, the BC Provincial Court, the Territorial Court of Yukon, and the Nunavut Court of Justice. And Sarah and Christie will be talking to us today about their practices, particularly as they relate to Indigenous law and climate change litigation. So without further ado, I'll go ahead and let you guys get started. Thank you.
Great. Thanks very much, Camden. I'm really pleased we have such a good turnout here in person. I'm Sarah Hansen. Just want to say at the beginning that the views I expressed today aren't necessarily the views of Miller Thomson. They're my views. So we always like to come out and start our presentation with a little bit of legal history for all of you about the Indigenous people's experience in this country. So I thought I'd start a little bit with that. I wanted to talk to you a little bit about our Indigenous Reconciliation Committee at the firm. And my reason for doing that is to give you some purpose to, when you're speaking with some of the other firms you might be dealing with over the years, to ask them what their Indigenous reconciliation program is. We have a preferential hiring program for students, Indigenous students as well. So I wanted to showcase that a little bit. But I'll just put up our presentation. You can see our agenda, and we're really, really happy to be back here. I have to tell you, I'm a U of C grad and an LSE grad, but I spent about the first 10 years of my career out at the University of Calgary and working with students. I coached a bunch of moots like the McGillivray Court of Appeal moot, the Kewaskum moot. I coached Jessup moot over at LSE when I was over there. And so one of the reasons why we approached Camden is I really want to try to get back to UBC, and I live 20 minutes away. I really want to try to breathe new life to my connection now that my daughter's a little bit older. So we balance, right? We balance. My right hand, Christie McLeod, will introduce herself, but she's an absolute rock star in the climate change area. I'm very impressed. We were up at Iqaluit, and now maybe we are one of the very few that have been in the Nunavut courts. We get dragged all over the country, actually, dealing with Indigenous rights issues. And we're both on industry side, we're on government side, we're on First Nation side. So I think a lot of the times we get hired is because of that breadth of experience and that ability to view things from all different angles, consistent with our life purpose. So I'll just share our little presentation here that we gave. And part of the work that we do on our Indigenous Reconciliation Committee is to educate our own firm. So if you think about it, I come from a partnership that has 550 lawyers and staff, or a pretty big undertaking. So on different opportunities that we have, we give some basic education on Indigenous peoples in Canada. So I'd like to take the opportunity to do that with you. I'm sure you're probably here for a reason, so you probably know much of this, but in case you don't, we're going to start with environmental assessment tools. So again, it's this hybrid that we have of real experience in environmental law and real experience in Indigenous law. And the two converge all the time. They're doing so in Canada in a number of different really high profile cases, but internationally, I studied public international law, focused on environmental law in London at LSE. There's a ton of environmental cases intersecting with Indigenous rights throughout the world. So I thought I'd just give you a couple of those. We're doing a lot of Indigenous-led assessments. So I'm going to talk to you about what I feel is a landmark one that we're doing now. I want to talk about Section 11 designations, because what the hell is that, right? Under the Environmental Assessment Act. Talk about shared decision making a little bit. We have a case we did up in the Northwest Territories in a place called Nene National Park Reserve for a company named Trophy Lodge. We're going to talk a little bit about that. Greenwashing. Christie will give you her background, but this is quite an interesting area in the climate change world. And then international Indigenous rights litigation. So just mind my time. So this, again, I mentioned our IRC committee. All firms were called upon by the Canadian Bar Association to come up with an Indigenous reconciliation response plan. This is further to the Truth and Reconciliation Commission calls to actions. It's one of the calls to action. So we started working with a plan in 2020. We have approval from our executive committee, which took a while, for quite a big and inspirational plan, I think, that draws on the toolkit that the CBA prepared. So firms should have this in place. Yeah. Firms should have a program for how they're reconciling Indigenous interests with the footprint of their firm and the work that they do. We've been preferentially hiring Indigenous students since 2017. So it depends on which office we hire into. That process is available to any Indigenous student. And we would encourage any of you to apply. We've had quite a number of students in our Vancouver office, Calgary, Toronto, really across the whole country. This is just to give you a sense, because it's how I educate my fellow firm members, even in Alberta. There's the location of the historical treaty boundaries in Canada, I think, is telling. It's here, at least when I was educating members of my firm. These are all of our offices noted here. So we have Vancouver, Calgary, Edmonton, Montreal, Markham, Toronto, Vaughan, London, Kitchener-Waterloo, Saskatoon, and Regina. And our main pitch was you should be doing a land acknowledgement, right? So I'm speaking to you today from the unceded traditional territory of the Tsleil-Waututh, Musqueam, and Squamish nations. That matters to me because I was born and raised in Saskatchewan, northern Saskatchewan, went to school with a number of Indigenous students at a predominantly Indigenous school. And so since that time, I've been working to achieve reconciliation. So that was grade 1 for me. But many of our members of our firm don't even know what treaties they're near, who their neighbors are. These are your neighbors. So we prepared this with Shawnee Manchalin, who was with our firm and has gone on to do amazing work, to create this really easy map to see who are your neighbors, where are the treaties, where was treaty adhesion in line with the provincial borders. So just, again, I'll take 5 minutes just to do a little background education, and then we'll get into what we came here to talk about, which is some of the litigation we work on. This is a quote from Johnny McDonald, 1887. The great aim of our legislation has been to do away with the tribal system and assimilate the Indian people in all respects with the other inhabitants of the Dominion as speedily as they are fit to change. So this was the stated intention of the government at the time. And then you see the law and the suppression of Indigenous peoples throughout all of these pieces of legislation throughout time. And it's not controversial. This is exactly what it said. And so in 1857, the Indian Act was actually called the Gradual Civilization Act. Any male person of Indian blood was considered to be a quote unquote Indian. I was out on a reserve 10 days ago, and many Indigenous people still carry around their card. They've been assigned a number. They'll show me their number, that they're registered to this band and this is their number before they speak. So you think about how it is that you're growing up that way, assigned a number. Status women who married out, I think all of you in law school know about what happened there. 1884, residential school becomes mandatory. Kids are forcibly removed. This isn't far off in our history. Almost all of the chief and councils that I deal with either went to residential school, or their parents went to residential school, or their grandparents went there. And you do see lasting effects of this on reserve. The pass system, a lot of people don't know about, in 1885. So the pass system restricted Indigenous peoples from leaving the reserve. without permission from the Indian agent, which was not given. So you see, not often given, you see a number of cases of Indigenous peoples being arrested for leaving reserve just to hunt for food. So we know about dancing being outlawed, outlawed entirely in 1925. Big one in 1927, Indigenous peoples are banned from hiring lawyers. So this is why we're seeing a lot of these Indigenous rights claims, land claims, cows and plows claims all coming up much later in time than you would have thought. And it's because they were not allowed to hire any lawyers. And you can see it continuing into 1951, where Indigenous peoples who received a degree to become a doctor, a clergyman, or a lawyer lost status. That's 1951. And then all the way down to 1996. So the last Indian residential school is closed. It's in Saskatchewan again, General Gordon, and that's the last school that was open. There's a big kind of connection to ESG. We get a lot of questions about Indigenous communities from our corporate clients asking about how they can be fulfilling the social aspect of ESG. Also environmental and governance as well. But you want to make sure as part of your ESG program that you have a program in place to be responsible and to be respectful to the Indigenous communities in which you operate, right? So again, along with other carbon emissions kind of work, we're dealing with advice to corporate clients on the ESG front too. Okay, so environmental assessment tools. So just to give you a little bit of background, you've got your federal regime with your Impact Assessment Act and your provincial BC regime with your Environmental Assessment Act. And the two change every election, right? So if you swap between Liberals and Conservatives, and oftentimes the Fisheries Act will change too. But they determine which projects should be assessed through those systems. And the BC system runs through the Environmental Assessment Act, which is a mammoth kind of institution, and reviews various what we would call major projects. If they meet the threshold or if you can pave the way for a Section 11 designation. A Section 11 designation is if an Indigenous nation believes that the adverse effects will impact their nation. So even if a project doesn't meet the thresholds that the government set, then it can still be designated a project. And then we'll talk about trophy, but we're going to talk about our most recent experience with the Highland Valley Copper Mine Life Extension Project. So I'll let Christie take it away. This goes right.
Awesome. Thank you, Sarah. So as Sarah mentioned, there was a new Environmental Assessment Act passed in BC in 2018. And one of the key changes of this act was that it allowed for the availability of an Indigenous-led environmental assessment. So under Section 41 of the Act, the minister can enter into an agreement with an Indigenous nation to either provide for a means to substitute another party or jurisdiction's assessment required under the Act, or they can establish procedures with that party to cooperatively complete an assessment and review a project. And so under Section 19.4 of the Act, if a participating Indigenous nation notifies the Chief Executive Assessment Officer of their intent to carry out an assessment regarding the potential effects of the project, then the officer is required to specify which part of the assessment will be carried out by the participating Indigenous nation. And so Sarah and I just recently, within maybe the last day or so, have been wrapping up an Indigenous-led assessment for one of our clients who did notify the EAO under Section 19.4 of the Act that they wish to carry out an Indigenous-led assessment of a big mine called the Highland Valley Copper Mine. And so this project is about an existing mine that already exists 75 kilometers southwest of Kamloops, BC. And Teck is the proponent who wanted to expand the mine, expand production, as well as extend the life of the mine. Currently, the mine is supposed to operate until 2028, and they propose to operate the mine until at least 2042. And so Sarah and I represent a First Nation, two First Nations who have joined together and have a governance unit called SSN, Kamloops-Sissequaquak, who wanted to assess this mine proposed expansion because it lies within their traditional territory. And so what SSN did was their joint council passed an order in council and established a process where they would carry out an Indigenous-led assessment. And this is something that they did previously for the proposed Ajax mine. and were actually successful in stopping that mine from going ahead. And so now this is the second iteration of that process where they carry out their own independent Indigenous-led assessment that is separate from, but runs parallel to the province, the provincial environmental assessment that occurs concurrently. And so SSN's Joint Council developed its own process, which was informed by their laws and governance, and which respects their cultural perspectives, their knowledge, and their history. They made up a review panel that's comprised of members from both of the two First Nations, Skeechesin and Tk'emlúps Indian bands, and it represents the family groups that are in those bands. And so the review panel heard oral evidence during a week-long hearing that occurred this summer in Kamloops, BC, and they heard evidence from almost 70 witnesses. And so we had witnesses appearing on behalf of Teck, the proponent. We had provincial and federal representatives. We had Secwepemc knowledge keepers and witnesses. And then we also had independent experts who appeared, some of who were retained by our client to examine the proposed impacts of the project. And so following the hearing, the panel members returned to their communities and they discussed with their families what they had seen, what they had heard, what they had read, and about the potential effects of this project on their territory. And then the panel also came back and met together on a number of occasions to determine how do we want to proceed with this project. The panel then made recommendations to the Joint Council, who decided whether or not they want to provide free, prior, and informed consent to this project to go ahead. And the SSN will be releasing that decision next week. So I encourage you to take a look at their website if you're interested in seeing the findings of that, which will come out next week. And now I'll turn it back to Sarah to talk about Section 11 designations and some more recent work we've been doing.
Thank you. Great. It's funny because when you look at the international cases that I'll talk about later, I just want to read you a little bit about coal. So coal and gold mining, as you know, it requires companies to dig huge holes in the ground. And now with these expansions internationally, they're growing deeper and deeper into the water table below them. So they have their heavy machinery, which can kick up dust and it can cause pollution into the air. There's chemicals they use in the mining of the ore, which are exposed to that water. And then that water is contaminated. And some operations, so for example, the second largest copper deposit in New Mexico, it's called a Freeport Tyrone mine, they have to pump water in perpetuity, right? So even after there's no copper found, they're going to have to pump mine in perpetuity. So there's a real increased demand for copper too. It's supposed to grow by 350% by the year 2050. So you will all be involved if you choose this path in those mines. That's nearly twice doubled between the period of 2019 and 2020 in the US alone. Canada has 127 mines. So another fact, we're a major player in this industry. Highland Valley Copper Mine being a surface copper mine, so it's exposed. It is the largest in Canada. So it's one of the ones that we really wanted to look at. It's also worldwide, copper mines produce about 21 million tons of copper per year. They contribute to around 0.2% to 0.3% of global carbon emissions. So think about how big that is just for this particular industry. So I just wanted to kind of frame that a little bit for you as to why we focus on what we focus. We do have a bit of a luxury, having done this for a while, to focus on projects that are meaningful to us. One of the ones with the Section 11 designation it's public, but it's kind of sensitive, so I won't talk about it too much. But under the Environmental Assessment Act, both federally and provincially, you can apply to designate a project. So even if you're doing research and you see the project doesn't meet a threshold, so let's say, for example, it's an existing mine and it's not planning to produce more ore over and above the scheduled thresholds, which you'll find in the reviewable projects regulation, you can still apply as an Indigenous nation. And so that's something you want to think about in your toolkit. Oftentimes we're now seeing, because of, urban creep, we're seeing a lot of areas that haven't been developed, and maybe for very good reason. Maybe they were Indigenous ancient village sites. Maybe there were pit homes. Maybe there was other, specific hunting blinds, for example, or ex-chim caves, where this is a highly spiritual site. And so they haven't been developed, but maybe the developer doesn't always know that. And so something to think about when you're looking at what tools are available to you. You can try to have the project designated, and then it goes through a really big comprehensive environmental review with a number of different regulatory players who would be involved, as opposed to maybe just a municipality or some other kind of regulatory authority that doesn't have as much oversight or technical background to look at. Trophy Lodge, this is an interesting case we just ran. You can read it for yourself. But this is, again, kind of an example of where sometimes we have a convergence of the Indigenous space into the business space. So this was a business that had operated since 1965 as a fishing lodge. It's pretty small. I think it had 16 or 21 rooms, something like that. But the federal government now is going out through Parks Canada and negotiating a number of agreements to establish Indigenous management boards in newly created park reserves. So this is called the Tyadanainene Park Reserve. And it was created for the Litsakai First Nation and others that, that was part of their traditional territory. But again, this lodge had been there since 1965. And the First Nation, Litsakai, supported the lodge when it applied to get a new business license to operate for new owners that took over the lodge. Unfortunately, the management board, though, the newly created Indigenous Management Board, did not support that business license, even though the nation had. So that was a huge amount of litigation. It was heard in front of Mr. Justice Regenbolds. Have a look at it in federal court. It was a lot of fun. But in the end, you can't just advance a case that says reconciliation prevents this business from operating in Tyadanainene Park, notwithstanding that it's been there for many, many years. You have to put forward evidence that you cannot reconcile the Indigenous interest, yeah? So if there are specific areas that we needed to avoid, our client was more than prepared to do that. If there were particular seasons we needed to avoid, we were more than prepared to do that. And unfortunately, all the way up to higher decision-making at Parks Canada, they weren't able to look at the full application of our clients to show how they were going to reconcile interest there. And it ended up being overturned on judicial review. And I'm happy to say our clients now have their license, so with the support of the nation. So I'll let Christie talk about greenwashing now. Thank you.
Thank you. So greenwashing is something that's not making up a huge part of our practice today, but it's something that we're keeping a very close eye on because it is another tool in the toolkit of how you can be holding companies accountable for environmental claims that they're making that maybe they aren't holding themselves up to. Greenwashing has been in the news a lot this year with the new Competition Act amendments that were passed by the federal government this past June. And so I think you're probably all familiar with greenwashing, but just in case, that term means when a company conveys false or misleading or unsubstantiated information to consumers about their product or their business and the environmental credentials about it. And so the new amendments that came through this past June by the federal government require businesses that make environmental claims to now be backing up those claims, either by adequate and proper testing or internationally recognized methodologies. And this has caused a bit of an uproar in the business community because both of those terms aren't yet defined. And so there's a lot of uncertainty and questions coming from companies as to what comprises adequate and proper testing or what methodologies is the Competition Bureau talking about. And so the Competition Bureau has said that they're going to be doing some stakeholder consultation this fall, and then they'll be releasing some guidelines that hopefully will provide some answers to companies in the future about what those terms mean and what are the requirements for backing up the environmental claims that a company is making. What we think adequate and proper testing means probably includes testing that's using reliable, scientifically accepted methods, that it's transparent, it's properly documented. And then internationally recognized methodologies, there's quite a few, but it probably includes the International Organization for Standardization, the International Sustainability Standards Board, and there's many others, but we'll be looking to the Competition Bureau to provide guidance on what those terms mean for businesses. The types of claims that we're seeing to date, though, in terms of greenwashing in Canada, a lot of it relates to misleading marketing. And so with the increasing demand from consumers for more environmentally friendly products and services, companies are often highlighting the commitments that they're making when they're marketing their products and services. And some of those companies are actually also doing the hard work to alter their operations and make sure that they're reducing the environmental impact of their operations, but other companies are sort of skipping over that hard work and just changing their marketing to make it appear that they're doing more environmentally friendly things. One example that you might have heard of that's ongoing right now is an investigation into Lululemon by the Competition Bureau. And so this was initially filed a complaint in this past February by an NGO called Stand.Earth. And so they filed a complaint with the Competition Bureau in February, and then the Bureau announced an investigation in April, which is still ongoing, so we don't know the results yet. But the complaint alleged that Lululemon was making false or misleading environmental claims in its website, specifically with regards to its Be Pillar or Be Planet marketing campaign. So throughout their website and materials, they were saying that our products and actions avoid environmental harm and contribute to restoring a healthy planet. And there was 4 sorts of misleading claims that Stand.Earth said arose from that material. So the first thing was that they were making claims about their products and their actions and giving the impression that those products were contributing to restoring the environment. The second was that they were overemphasizing these minor environmental benefits and sort of deflecting attention away from the substantial environmental harms that were actually resulting from their products and services. The third claim was respect to their greenhouse gas emissions targets. So Lululemon presents a goal to reduce its Scope 1 and Scope 2 emissions reduction targets, so the direct emissions from its operations and then the indirect emissions from its operations, but they were ignoring the Scope 3 emissions, which is sort of the whole life cycle emissions of the product from cradle to grave. And this is important because 99.7% of Lululemon's emissions come from Scope 3. And so they had a target for the 0.3% of their total emissions, but were ignoring the vast majority of their emissions in their target. So the complaint takes issues with that. And then the last claim was about the company's vision or goals or commitments. So they were saying things like, we're restoring a healthy planet, but it ignored their enormous supply chain, the amounts of water that they're using, that they rely heavily on polyester and other materials which are derived from fossil fuels and the consequences of doing that. So this inquiry is still ongoing, so it's interesting to watch, but it does make clear that businesses need to consider both the literal meaning of the claims that they're making and both the general impression that's conveyed by a representation, such as we're contributing to a healthy planet. And so under the Competition Act, the commissioner conducting an inquiry doesn't actually have to find that someone was misled by a claim, just that the claim was made publicly and that it was untrue or misleading. So it's really about the impression that your marketing is giving people and not that it actually had to materially mislead a specific person. Another well-known greenwashing example in Canada, I like to raise this one because it occurred before the term greenwashing came about, so it's not always associated with greenwashing, but it's the Volkswagen scandal that happened in the mid-2010s. So in 2015, Environment and Climate Change Canada launched an investigation of Volkswagen regarding their compliance with the federal vehicle and engine emission regulations. And what they found, you probably all remember this, it was pretty big news, but between January 2008 and December 2015, Volkswagen imported nearly 128,000 vehicles into Canada that were equipped with something called defeat devices that reduce the effectiveness of the vehicle's emission control system while it's operating and violate the emission requirements under the regulation. And so this led to massive fines. It went to court, but then there was a settlement agreement approved by the court in 2017, where Volkswagen agreed to pay a combined $2.1 billion in damages for misrepresenting their vehicles as being green. And then in 2020, they were ordered by an Ontario court to pay an additional $196.5 million after pleading guilty to 60 charges of offenses under the Canadian Environmental Protection Act for misleading information and unlawfully importing these cars into Canada. So the penalties for greenwashing can be very steep, both in the courts, but then also under the Competition Act. The charges for greenwashing can be as high as $10 million for a first offense, $15 million for subsequent offenses, or 3% of the corporation's annual worldwide gross revenues, whichever is higher. So that's a pretty high penalty that companies might be facing. And then the Bureau can also mandate corrective measures, such as requiring a company to do a public retraction or to correct their misleading claims. So I think it's important to consider how companies can avoid greenwashing and avoid getting themselves into these sticky situations. And I think the first lesson is that companies should really be specific. They need to be avoiding buzzwords and broad claims, things like green, sustainable, environmentally friendly, all of these buzzwords that don't really have a defined meaning. And now with the new laws in the Competition Act, you can't really make such sweeping environmental claims without providing more information to substantiate those claims. So if a company only knows about a certain product or a portion of the product, then they should only make a claim that is limited to the scope of that. Don't make a claim that's broader than what you know. Just limit the claims to what you actually have sufficient evidence to back up. And ideally, companies will start to work through measuring an environmental product throughout its entire life cycle. So from that cradle to grave. So if you're doing a mining company, look at from when the ore is extracted from the ground all the way to being used by the consumer at the end final product. A broad claim that we're seeing companies make a lot is net zero, and that can be a really tricky word. Several Canadian companies are planning to expand their oil production, but are also saying that they're going to be net zero by 2050 or a certain date. And that's because they're going to unduly rely on carbon capture and utilize storage technology, which isn't necessarily proven at the scale that they're hoping they want to rely on it. And they're hoping that that will allow them to continue to produce oil and gas. And so that's an example of a claim where they're not necessarily having the evidence to make that claim that they're going to be net zero because the technology isn't there yet. If a company is going to rely on offsetting, or they should be making really clear that that's how they're going to be meeting a certain target that they plan to meet. Companies should also be backing up their claims with data and evidence, so that adequate and proper testing under the Competition Act. But companies can also voluntarily disclose information. We're seeing this a lot with CSR, so corporate social responsibility reports, or ESG reports. And those are good, but it does allow a company to decide the narrative that it wants to provide information on. So it's also good if a company does something more objective, like a carbon disclosure project submission, where it's more of a question and answer about providing data and answering questions that are asked of them. And companies can also seek designations or certificates to set them apart. And so one example would be a certified B Corp company. And that's based on an assessment of a company's social and environmental performance. And it's quite a robust guideline and assessment process to go through that. And so that's just another way to ensure that a company is doing what they're saying that they're doing. And then just lastly, I think it's also important to have a company-wide approach. So it's important that ESG issues not just be relegated to a small environmental team within a big business, because the issues that they're covering really do impact all areas of a business. So even within the E of ESG, they're still going to need to consider the full supply chain. So that might require, distribution, marketing, communications. There's all sort of different aspects of the business that will need to be involved in disclosing information about, the E and the ESG, or the S and G as well. So it's important that it not just be siloed to a singular or small environmental staff or team. So with that, I will turn it over to Sarah.
Well, thank you.
Yeah.
I'm just going to look at our time because I know, we're good for time. I know part of being here today is like, what do we do every day, right? What's a day in our lives? So I just was going to run through some of these international cases for you, and then I'm happy to talk about a day in our lives. A day in our lives, I know Jay has been with us. It's busy. It's busy. If you want to be this kind of a lawyer, you're on the phone a lot. Yesterday, I'll give you an example. I went into the office at 9:30. Christie and I talked about this presentation for, I think, 45 minutes to an hour. And then I was prepping media online from 11 till 1:30, where I had to break for lunch because I was feeling lightheaded. Then I came back to that till 2. And then you're making a bunch of submissions to the environmental assessment office. So you're writing then, which we love, for an hour. This report that we wrote was just with a lot of thought and a lot of excitement to merge finally all this Indigenous evidence we had with all this really good technical evidence. We had 17 technical experts on our own, so a lot of writing, but you know that in the law. But then we're running into another meeting on strategy about, a whole bunch of other cases. We're always looking globally, what's going on in the world. We're always working with experts and trying to figure out, well, look, they're doing this in Australia. So how can we bring that into Canadian law? So my main goal as a lawyer has been to, when I read a case and I don't like it, I try to change it. Really, that has been a big part of the direction I've taken in my life. So, for example, on Indigenous knowledge keepers, they were having elders that they said at one point in time you could only take their evidence one at a time. And I'm out in the community, and they always meet as large groups of elders. That's how they always told their stories, was as a group. So we applied to have them meet opposed as a panel, and we won. We didn't like the law, we changed it. But there's a number of different times where we've done that. So it is kind of trying to stay at the forefront of everything and really watching internationally what goes on. So that's an easy day. So a hard day is when, we're flying to another city to do negotiations with an Indigenous nation on behalf of a company, or we're figuring out it takes 2 days to get to Iqaluit to argue a hearing for 3 days. So, we both have families, and we make sure that we have a large team so that we're not burning ourselves out. And, we do have like 36 lawyers in our litigation group now. So it's a really good team that you can draw upon so you can go away. I don't want you to think that we work 24/7, because we don't, but it's lively, and then we're in judicial reviews in court that last for several days and weeks. If we're in trial, we're stuck there for weeks too. But you're all over the place. It's very boring. It's never boring. It's very dynamic. You're in the Supreme Court, then you're in the federal court, then you're in BC, then you're all in Alberta. Maybe we're in the Yukon, maybe in Nunavut. You have to learn all the rules of court. So it's a calling, it really is. So you have to be interested in knowing about many things just because it's cool. And then you're really fighting for a good purpose in what you do. And you're not always going to be there in your first year at law. Like I had to work for 5 years in the oil patch in Calgary, right? So both my parents my stepdad and my mother are geologists. So we cannot talk climate change at the dinner table at all. But you have to learn the ropes too. So you have to be on the other side to learn everything on both sides. Yeah. So you may not get where you want to go eventually. You will if you keep at it. So these are just, I don't know, I just mentioned that for the day in the life. That's kind of what our lives are like on the daily. Balanced with families. So trying to make sure we leave at 5:30 at the latest, which is important to us. I think different firms have different outlooks on that, but that's mine. So I just want to tell you about these cases because you should be keeping an eye on them. I want to tell you that Indigenous peoples comprise, as you know, less than 5% of the world's population, but their territories contain 80% of the Earth's biodiversity, including forests, deserts, grasslands, marine environments. So if you think about that, now you know why Indigenous nations are bringing all these claims, because 5% of our population is affected. 80% of these territories include the Earth's biodiversity. So that's why we're seeing all these cases. And that, you don't have to trust me on that. That's Dr. Maria Antonio Tigra that had a really nice report showing all the statistics about climate change and the impact on Indigenous groups. You know, we have UNDRIP, obviously, United Nations Declaration on the Rights of Indigenous Peoples. We've adopted that into our BC legislation under DRIPA. We've adopted that federally as well, but that's where the work begins. You know, that is where the work begins. It's now the development of action plans, or how do we really go about doing that is being worked on. There was a claim, maybe I'll skip the more than one claims in Canada. We already talked about Ajax being a real convergence of Indigenous rights at an area called Peepsis, where a mine was proposing to commence construction and undertake production, and it was right in the heart of a cultural keystone site, and that was a very long fight we had to stop that mine from being constructed, and so it was not. But it's not the only one. So if you look at the deforestation issue, the casino group is kind of interesting. So what's happening is that the French government passed this duty of vigilance law. I don't know if you've had a look at it, but do have a look at it. It's quite interesting. So what was happening is that meat that was harvested from suppliers who were grazing their cattle in the Brazilian Amazon was being sold in France, and then by this casino group. It's a chain of groceries, and they were involved in a lot of litigation over that because they violated this vigilance law. And so the litigation traced straight back to the human rights aspects and environmental aspects from clear cutting all the Amazon rainforest to make way for cattle, right? And so the particular wow, I always try, even though my pronunciation is usually horrible, I still try. The First Nation group there said, you know, we've been clear cutted to the point of no return. We're not able to maintain our culture and our way of life. And you're selling meat from these suppliers, which are linked to what was alleged to be illegal deforestation. So that's an interesting the case to have a look at. It shows a conflict between ranchers and Indigenous peoples, but it also talked about the nation itself. So there's a real history there if you look at that nation, which is not dissimilar to Canadian Indigenous populations. So this nation was on traditional territory, which was taken over by different industrial development and then moved to new territory, where it was going to be protected this time, and then it wasn't again. So it was some 1,500 families or so that after being moved were affected again. So the airborne contaminants, there's the Dayak Indonesia group has a great website. So you can have a look at that, but they're trying to protect the children there from airborne contaminants that are causing a lot of disease. Again, it's the expanding palm oil plantations. Some of those fires are so bad that the airborne contaminants are now making the people sick there. And so the Dayak, there's a large foundation online where they've commenced some climate change litigation to try to prevent more impacts and protect the forests and fight for the Dayak community. I mean, these aren't, it's not, to me, it's not a bunch of protesters groups. It's not. It's groups that are really seeing impacts in their communities as a result of climate change and trying to stand up against that. Last one is that the industrial exploitation, Te Awa Tupua River, by the Wanganua tribe in New Zealand. And we watched that case because the court was able to give legal personality to the river itself, which you've probably studied it, but it's a good case to look at because they're, with this concept of all my relations in Indigenous laws, it means that like everything is connected. Quite literally, everything's connected to each other. So if the river's unhealthy, then that makes you unhealthy too. So that's part of the law recognizing, I think, legal personality to that. And I could go on and on and on. There's quite a few other international cases that were we're watching and trying to apply some of those concepts in Canadian law as well. So maybe I'll stop there. I think you do some questions, right? So I'll stop sharing
Okay.
screen.
Well, thank you very much. Let's have a round of applause for that great presentation. And we do have plenty of time for questions. So if anyone in the room or online has a question to ask, now's the time.
Don't be shy.
I just had a question about that Volkswagen scandal that you mentioned. So I remember that was kind of going on internationally, just in Canada. Was it first discovered by Canadian authorities, or how did it come to?
You're testing my memory here. I think it did occur in the US as well. And so I think there was some related litigation and investigations that happened in the US. And then it was also, hey, we think this is happening in Canada as well. I would have to double check on the timing of who was first, but I know it was first. I think US was first. Yeah. Yeah, good question.
I was gonna say there's those are very interesting cases because there's big litigation resolved like in the US and then trickle down to Canada for the same kind of settlements. Yeah. Yep.
The potential fines for greenwashing. Have there been any cases where those like high five, like with 10 million or 3% of global, like, are those levels of fines being issued, or does it tend to be somewhere lower?
There is the opportunity to issue fines, but there's also the opportunity for settlements. And so one case was the Keurig scandal that happened, and that was related to the Keurig pods that you put. They were making claims about the recyclability of those when they weren't necessarily recyclable in certain municipalities. And so they were actually able to come to a settlement agreement. And I think the fine was $3 million. So a smaller fine, but because they were able to work together and kind of cooperate, I think there's a willingness on the part of the regulator to come to a solution if they can. And then, the fines are always there as an option if settlement isn't. And
Would that just go to the regulator, or would you let it more like a class action style where it gets paid out tiny chunks to?
I believe most of it went to a fund, and then it goes through the fund and is determined to be used for, perhaps studies or research, restoration measures.
Very nice. Yeah, this is funny. This is interesting because we do a lot of work on the fishery side of things too, and on the there's this environmental fund that these monies go to for it. So it's interesting, like why are they going to a fund, right? Where some of these Indigenous populations are really affected. The Prairie Hills case is one we looked about where there was a operation, I think it was a mining operation, and it took out an entire river, like a whole bunch of fish died. And there's an order which we've had a look at that's set up and targeted where the funds would be paid. And I liked that as a model because it looked at sort of an Indigenous monitoring group function or a scholarship function, or studying on how you could fix this particular area, as opposed to moving all the money to some other fund that would do different targeted things unrelated to the area. So that is an area where we're trying to move it to be set up in a way that it can give back to the communities it affects, which I think sometimes is the intent of the prosecution too. It's just maybe legislatively they have to be creative. Yeah, good question though.
Hi. Thanks so much for your presentation. I was just curious about the Indigenous-led environmental assessment you spoke about at the beginning of the talk. I'm reasonably unfamiliar with the Canadian environmental law, so new arrival here. But it sounded like from what you're saying, those are currently set up to be optional. So in the Section 41, it's that applicants would request to have, like it would be their choice if they want to engage with Indigenous-led assessment. If that's correct, I'm just thinking about sort of the you developing an Indigenous legal scholarship about the role of greater participation and decision-making for Indigenous people as a means of further recognising Indigenous sovereignty. With that in mind, I'm curious, in your experience, have you seen any appetites in environmental law circles or in politics for shifting to something that may look more like a mandatory model? for Indigenous-led assessments on
Perfect question. I
environmental
love it. I'll take that one. Okay, so when we did our first Indigenous-led assessment at PEEPSIS for this the Kamloops, the Secwepemc, we were the first, one of the first that had done that. And so Madam Justice Wendy Baker, who's on the Supreme Court now, had run that hearing. And it was really the nations saying, well, I don't particularly care if there's no legislative right for me to do this. I'm going to do this anyway. And then you decide what you're going to do with it, right? So there were government to government negotiations that we were involved with to be able to convince the regulator that you should at least have a look at this report. Yeah, first step, and be required by agreement to incorporate it into your effects assessment. So that was key, and that we wanted the ministers to look at it. So all of that happened. So that was for the KGHM Ajax mine at PEEPSIS. But these are not small undertakings, right? This is like, at that point, I think the panel had 46 members for a panel. And then, Indigenous knowledge keepers, you need participation from the company as well, which we've had in both of our Indigenous assessments to their credit. They'll send their technicians there and explain what their application is. You invite government as well. So we invited, in our last hearing, we invited several regulatory authorities, both federally and provincially, and they could present if they wanted to the panel as well. But subsequent to PEEPSIS, there's been a number of other ones that you could look at. There's Squamish did their own Indigenous-led assessment on a wood fiber project. Probably Tsleil-Waututh, everybody's aware, they did their own assessment for the Trans Mountain project. And so now the requirement is in Section 19.4 of the Environmental Assessment Act, that if an Indigenous nation would notify that they want to do their own assessment, then the minister can set as Christie had said, the portion of the hearing that they would run and the timelines. And so for this Highland Valley assessment, we had to be engaged with the EAO to get ourselves into their assessment plan, so that you have to make sure that mechanism is there as well at the end. But ultimately, the decision is with the government currently. So you think about other instances where nations have title established or Aboriginal rights established, like Musqueam with fishing rights, or title like Chilcotin. What happens there? Like, what happens with the decision making there? Which is what we're really interested in, is trying to make these assessments easier, because they take a lot of work, but they really do build up a community too. I have to say, they really bring people together. Yep. Camden.
Yeah, so I actually also had a question about the environmental impact assessments, and I asked this question out of total ignorance. So I'm just sort of like traditional environmental impact assessments in my mind would be performed by like environmental consultants or like experts, for lack of a better word. Is that correct?
No. If you're
Or the
talking
government,
about
I don't-
environmental investigation or an inspection, yeah, always
Okay.
by environmental consultants. So,
Okay.
so they would be the people out there looking at the soil, sediment, water, yeah,
Okay.
groundwater.
So for like I guess my question is, with respect to Indigenous-led environmental impact reports, how similar are they to traditional reports, for lack of a better word, in terms of, criteria or methodology? Like, are they similar, or are they looking at totally different considerations?
No, that's a good question. So you could talk about the 5 pillars. Did you want to talk about the 5 pillars? There are similarities if you think about land, sky, earth, and water, right? There are similarities in terms of what you're going to look at. I think the big differences are that oftentimes the environmental consultants don't know Indigenous law. They don't know oral history evidence. And it's not just about, we were here and we did this. It's about, well, okay, so that aquifer is connected to this aquifer, and that's part of this watershed. And we've controlled and managed that watershed in this way since this time immemorial, right? So we really do have expert fishers, expert hunters, expert trappers that come in and harvesters, particularly of medicines. and other roots, shrubs, plants, that they can really explain, where you have to make sure your areas you're going to avoid or that sort of thing, or what your impacts could have that you would never anticipate as an environmental consultant because you just don't have that knowledge. So it is about kind of walking on two legs is the concept. So bringing in the Western technical knowledge with the Indigenous knowledge. But a lot of times Indigenous knowledge, they're experts in their own right? I think it's different also, though, with the 7 generations of thinking. So Indigenous populations think 7 generations out, not just like a traditional environmental consultant might look at the lifespan of the project, where they're looking a lot longer. Maybe one other instance is this concept of being good guests in the territory. So a good guest is someone who respects the Indigenous laws, who, if told to do things differently, does things differently, and is a good kind of corporate citizen. Oftentimes our environmental assessment consultants or legislation, we don't look at who makes the application and whether we consider them to be a good guest or not. So there's a lot more examples, but those are a few. Good question.
I can add a little bit to that too, with respect to our specific Indigenous-led assessment that we've been looking at. The big difference is the temporal boundaries and the spatial boundaries. So with respect to the Highland Valley Copper Mine environmental assessment conducted by the province, their base case, so they have a base case and assessment case. The base case is what they're going to measure the impacts of the mine if it goes ahead, what it would be. And so their base case starts at today. It says, okay, the mine's been operating for 7 decades already, since 1962. It ignores all of those impacts. It ignores, pre-contact conditions, pre-mining conditions, and says, the base case is today. Let's see what the impacts of the mine would be from today onward. And so with an Indigenous-led assessment, we're saying, we would like to see pre-contact conditions. We would like to see pre-mining conditions. Comparing the impact of the mine from pre-1962, or even better, pre-contact, pre-colonization, to today, and looking at the cumulative effects of the mine over, its operation to date, in addition to the proposed impacts as well. And then in terms of spatial boundaries, the environmental assessment conducted by the province is limited to the effects of what they call a regional study area, which is different for vegetation and ecosystem and different for wildlife. So they have these different regional study areas, but they're only looking at the effects within that. And so they don't look at, for instance, the effects of wildfires that might occur outside of the regional study area, or climate change, because it happens outside of the regional study area. They're not looking at the cumulative effects of that. They're really just kind of siloed and really compartmentalized and looking just at the specific effects. So that's a way in which the Indigenous-led assessments provide an opportunity for a more holistic view of, just a greater spatial or temporal boundaries.
Yeah, so there's a lot to be learned. So if you study a specific species, even in that, like not looking at it from a compartmentalized view, you'll see a completely different story than you would if you just looked at this tiny little area and hoped you might see a moose one day. Yeah. I know you have a question back there. Back row, gotta be one question. Okay, I like to call on people that wouldn't necessarily speak first because they're some of the best questions.
I'm curious to know about the comments that you made, Christie, about net zero and how net zero commitments are greenwashing. I know a lot of those net zero commitments are so far out into 2050. So at what stage between making the commitment, their cover these reports until 2050 when the commitment is actually due, would the competition bureau actually step in and sort of investigate the greenwashing stuff?
Yeah, that is a good question. A lot of companies, and even in legislation, if they're setting a net zero target, they're also setting milestone or interim targets. So you can see that in Canada's federal legislation, they have a net zero target, but then they also say, okay, we're going to set milestone or interim targets. And so if a company or country wasn't meeting those sort of interim targets, that would be an opportunity for the Competition Bureau to step in and say, hey, you say you're going to be net zero, but you've missed your last 3 interim targets. Maybe that would be an instance of greenwashing. Yeah, it's a good question. And I don't think that they have necessarily done an investigation into specific net zero. I do know they have an ongoing investigation into Pathways Alliance based on some of the claims that they've been making. That's still ongoing, but it'll be interesting to see what they have to say about that, because that is related to sort of net zero and the claims that Pathways Alliance is making, while also increasing oil and gas production.
Yeah, what about governments? Easy for other companies
Yeah.
get there if they don't meet their own targets.
Yeah. Sarah just said it's also an issue for countries as well. In Canada, for instance, our emissions increased by 16.5% between 1990 and 2022. So Canada's a great example of, doing the right things and saying the right words, passing the right legislation. But then if you look at our actions, we're still increasing our emissions all the time. So yeah, it's definitely an issue for countries as well as companies. Yeah, just next to you here.
Yeah, that's okay with you. Okay,
God.
I don't know if you remember, but I spoke to you in February, before entering the Allard, and I remember you said you were interested in environmental law and Indigenous law. Yeah. And it's cool to see you're at Thomson now. My question is, I guess, like, what's a day in your life? Oh, good question. Sorry.
1 sec.
Oh, I can't say.
Without talking about a private arbitration. Okay.
Okay, so, I love the things that Sarah and Christie talked about today. I got to work on, help with, they had a legal question, research, I did that. I got to help, prepare some of the documents, look at the reports. What else did I do? I feel like I did a lot of there was interesting questions that, Sarah and Christie had to do, you'll find it out, and so I did. Or some other, I don't know, there's notification requests, there's yeah, it was kind of out there, so they're kind of doing a lot of things. There's a lot of things to go. And so it was oh, there's this project, we can jump in and help on this, but also got to work very close with the Valley Compromise over a period of time.
No, and you're great too, because we can't talk about one other big thing going on, but a lot of times we do draw on international cases, right? So one of the first things I said to Jay is, what's going on internationally with this? And we really want people on our team that will just, okay, well, I'm going to go look for you. I'll go look. Obviously, you're not an international lawyer yet, but I'll go look and I'll help out. And so it was quite a lot of that, but yeah, there's a lot going on. You had a question.
Sure, a very, very high level one, but I was very struck by your map you had up originally.
Okay, yep.
And so I'm just curious, the treaty First Nations, are all those treaties still legally valid and everything? And then we come to BC on the unceded territory. And what's the sort of legal basis in British Columbia when there's First Nations involvement?
Yeah, really.
Very high level. I don't know if there's a
No,
short
I'm
answer.
happy to talk about it. So we have some treaties in BC, just in the northeast corner, Treaty 8 there, because these treaties were for the most part signed east to west, and by the time they came to BC nations were saying, I'm not signing any of that. So we do have nations that are set aside on reserve, but there's no treaty. So that's why you see all the land claims here. Yeah, so the status of the treaties is most First Nations still obviously live under treaty, right? They have their treaty card. They're part of that treaty. They have certain benefits flowing from that treaty if they're living on reserve. There are there's some income tax treatment if your income is derived from reserve. But there's a lot of claims right now about treaty entitlements and failure of the government to comply with treaty obligations. Restool was just a massive case you probably saw at the Supreme Court of Canada, right? For Canada's failure to adhere to the treaty promises that it had. It's billions of dollars. So there's a lot of continued litigation. A lot of these treaties were set aside, and then over a long period of time, reserves were created, and then there were approaches made to surrender portions of reserves. So there's a lot of litigation about land surrenders. There's a lot of litigation about, have you heard of the Specific Claims Tribunal? So there's a whole bunch of claims at the Specific Claims Tribunal about cows and plows claims that again deal with treaty entitlement and treaty promises. Yeah, it's quite fascinating actually. So if you look at the Yukon, they have this umbrella agreement so talking about, these are the historical treaties, I would say, but there's modern day treaties too. So there's the Nishka modern day treaty, there's Thomson, there's a number of nations that have been 24 years in the treaty negotiation process. Up north is treated differently than kind of the other provinces with these umbrella agreements and the nations signing on to those. So this is quite complex area, but it's very interesting. Yeah. A lot of litigation and other negotiations going on. Yeah. Yeah, this is a great chart, isn't it? Yes, of course.
I know that there's work going on to come up with a harmonized securities reporting standard
So you
provinces under ESG reporting. And if you, I mean, those haven't been announced by the provinces yet. They're still do you anticipate that when that happens, there will be, I guess, a mandatory?
Yeah, I'm curious to see what they're going to do in terms of harmonizing the standards and releasing more information on disclosure. I opened an article that I meant to read before because they made some announcements earlier today or earlier this month about the taxonomy report that the Sustainable Finance Action Council released in terms of mandatory disclosures for financial institutions, and there will be more information coming in terms of that. They released that report, I think, 2 years ago and still haven't provided sort of next steps on disclosure. So I think that that's coming soon, I hope. And then I don't know if there's a timing for the harmonization and release of those standards, but I think they should be coming soon. I'm hopeful that the Liberal government, while they're still in power, will try to push through some of these things a little bit further, because with an election maybe next fall, maybe earlier, there could be a change in government, and it would be good to see their continue to move on this while they still have the power to do so. So I'm hoping that they'll continue to move, but it has been a little bit more slower moving than I thought. And I think it will be important once they do release those.
Are there any last questions? Well, if not, let's have another round of applause. Thank you very much.
Thank you.
Yeah, and thank you both for a great presentation.
Thank you.
Thank you.
Thank you very much for inviting us, Camden. Thanks.